Hello guys, welcome to my YouTube channel. In the last session, we have extensively covered what is meant by legal jurisprudence, its definition, and also we covered how it is interdisciplinary and multidisciplinary in nature. And today's session, we are going to cover how we interpret, like rules of interpretation. Can we interpret the laws like anything and everything? Can judges do that? Because they are judges, they can do anything. Like they have any kind of the set of boundaries or not. So when we look at the constitution, in the first year, you have read about the constitutional law. What is constitution? Constitution is a limitation of the power. Like that, in the legal jurisprudence also, when we do the interpretation, it should be under the ambit of constitution. This is the basic rules that in all the democratic institution, whether it is a US, England, or India, or any democratic institution, the interpretation must be within the ambit of constitution. So the basic rule, basic idea is that interpretation must be interpretation and it should not descend into interpolation. What is its mean? So in every rule, let us take one example. I will give the case laws and I will explain the facts, or I will give some kind of the example. Let us analyze that. Based on that, let us understand that. Okay. Fine. Interpretation must be interpretation and it must not descend into interpolation. What is its meaning? I think you have read about the Maneka Gandhi case. In that, fact of the case is that she wants to travel abroad, but she's been restricted. Her passport has been taken by the government and it said that you should not travel to the abroad. So she directly approached the Supreme Court under the Article 32 of the Constitution. Supreme Court tell that her liberty is under the threat. So at that time, it interpreted the Article 21 of the Indian Constitution. What Article 21 of the Indian Constitution says so? It says that no person shall be deprived his or her liberty except procedure established by the law. Means what? It is written like that only. At that time, Supreme Court interpreted that liberty can be taken away, but it should be fair, just, and reasonable. These three principles it has given: fair, just, and reasonable. And these three words not at all there in the Constitution. How it comes? It comes through the constitutional morality or a constitutional conscience of the judges. We interpreted the Constitution is the one of the law. So whole Constitution, what Constitution is that? Constitution is all about the laws. There are various laws are written and it interpreted. Our judges, what they did, they interpreted the Article 21 and they gave these kind of three principles. So liberty is not unlimited. If liberty is unlimited, you can do anything and everything. Like you can go, you can destroy anyone's home. But under the liberty, you can move to anywhere. Like if it is a defense corridor or a defense sector, you can travel to that also. But there is a restriction. Why that restriction is okay, fine, because why? It is under the national security. So such kind of the curtail must be there. Liberty is not absolute. So liberty can be taken, but it should be fair, just, and reasonable. So how it is interpreted? So interpretation is also very time dependent factor, as I already told it in the very extensive video in the last class. So this is the basic idea that the interpretation, the legal jurisprudence, when we interpret the laws, it must be under the ambit of constitution and it must be interpretation. It should not descend into interpolation. Interpolation means what? If Supreme Court have said no person shall be deprived of his or her liberty except the permission of Supreme Court. If it make a rule, if it interpreted the Article 21 like that, then definitely it would violate the legal jurisprudence, or it is contradictory or paradoxical to the constitutional laws or a constitutional conscience as a whole. So it did not do like that. So interpretation must be interpretation. It should not come under the interpolation. But there are various critics are there. There are various scenarios in that interpretation is being extensively made. There are various cases. For example, just like I will give you, Char Dham project is that. So Char Dham project under the environmental or a sustainable. Char Dham means it is Kedarnath, Badrinath, four dhams are there. So in that, Supreme Court withhold the judgment and it costed around 1,500 crores because of delay in the project. Okay, delay in the construction project. It is also under that at that time. It was under 2019 or 20. At that time, this one was happening. China Galwan crisis was happening. At that time, Supreme Court withheld that. So such kind of, it is also criticized that judicial overreach. If you interpolation of some kind of the things, it is called as this one. It is criticized as judicial overreach. There are various critics. Critics must be there. Critics will help to reform and transform the institution as a whole. But at The present time, let us not go in depth into these kind of the political news. Let us stick to these kind of the rules. So second rule is what that. Second rule is given by the Salmond. Salmond, who is Salmond? Salmond is a legal scholar of the UK, Britain. So he tells that in the legal jurisprudence, there is a grammatical and logical interpretation must be there. What is meant by grammatical interpretation? I will give you one example. For example, no vehicles are allowed in some kind of the road. There is a road called X, and in that X road, no vehicles are allowed. Vehicle means what? Car, bike, rickshaw, or anything you can take. It should not be allowed. It means no vehicle is allowed. Okay, only walking is allowed. No vehicles are allowed. So logical interpretation means what that? For example, ambulance came. Ambulance directly approached that. Someone complained, okay, ambulance traveled in that kind of the X pathway, and it is the violation of the rules or laws which we make. So is it contradictory to that kind of a thing? No, it is a logical interpretation because there is a need. There is a this one. There is a utility for that. He is a critical patient. He is in the ambulance, so he is under severe condition. So ambulance traveled in that road. So what is that? That is the logical interpretation. So when we look at the grammar, when we take the grammar as it is, like we could not able to change, then that becomes a rigid. So society is not a rigid. So social needs are not rigid. Human desires are not rigid. So laws are also not rigid. So what is the basic this one things of the judges is that to see the social needs, as I already explained extensively in the last class. So grammatical this one. Okay, no, one more case. If we take that, one more example. Let us take. So all the graduate students are allowed for some kind of the X or Y post. Some kind of employment is there in the bank. So all the graduates are allowed. Supreme Court, what or any court, High Court, tell that only 5-year graduates are allowed. But it is not there in the law or rules. Okay, but court interpreted it like that. It is not logical interpretation because only graduate are allowed. 3 years also graduation we can get that. 2 years also we can get. 4 years also we can get. If it limits that 5 years, then that is the violation of the this one interpretation laws, rules of interpretations. So okay, fine. Then this kind of the so it will lead to what? Interpolation, not interpretation. So interpretation must be interpretation, then it should not lead to interpolation. Okay, fine. So this is grammatical, then there is a logical. So logical means we can interpret anything. No, there is also limitations. Let us see various rules are there. So when we use the logical interpretations, okay, when the laws are inconsistent in nature, what is meant by inconsistence? For example, one law is that. So Environmental Protection Act 1986 is that. So in Environmental Protection Act 1986, it said that no industries should not allow the wastage directly to the flowing water. So if it would have been implemented in 1986, every this one industrial corridors have some kind of the treatment facility. Rivers would have been clean at that time, but no startups or enterprise will going to invest in such kind of the industries because cost will going to increase. At that time, if you go to the court by telling that this kind of the waste is coming to our water resources, water pollution is taking place, court will not accept that because see, economical growth is also important. So we are not a developed country, we were a developing country. So there is a inconsistencies that we need to think, we need to use the judicial conscience needs of the society. We need to tell that if the court proclaimed that you need to treat this one, the industry would have been collapsed. So such kind of this peculiar condition or a needs of the society, we need to balance that. So that is what the inconsistency is that. For example, if the law is incomplete, what is meant by incomplete? For example, attempt to murder. So what is meant by attempt? Only attempt to murder is there in the IPC. Oh, if I hold the revolver, is it an attempt to murder? Like I just, for fun, I just hold the revolver. Someone complained that it is going to be an attempt to murder. Is it going to be an attempt to murder? Definitely not. So for that, what court have done, if you read the criminal laws, there is two tests, one unequivocality test and the proximity test. So court will test these kind of the applies. If you read the criminal laws, you will going to get into this detail. What is that? There is an inconsistency there. There is no definition of what is attempt. How is it attempt or not? Is there intention? Everything we could not able to assess. That we need a comprehensive fact for that. So when the laws are incomplete, laws cannot able to fulfill all kind of the things, all kind of the dynamisms of the society. Okay, then there is ambiguity is there. For example, if we look at the environmental laws, there is a lot of ambiguity. For example, Forest Act of 1927. In that 1924, I think so. Okay, in that act, only those forests are considered as forest which is notified by the government. But Supreme Court, what it said, so here was ambiguity. Forest definition of the forest is very much ambiguous. So when we look at the grammar of the forest, so how we need to interpret the forest? What is meant by if a one tree is there, is it a forest? So what Supreme Court told that if it contains the characteristic of the forest, what is the characteristic of the forest? There must be a kind of the animal, insect species must be there. There is this much amount of the tree, this much square kilometer must be there. Then it constituent of the trees, wetland, lot of things are there. Then only it is considered as a forest. So when there is an inconsistency, when there is an incompleteness, when there is ambiguity within the grammar, when the law is written, there may be a grammar interpretation like grammatically it is correct, but it is not every time we cannot apply into the circumstances. As I told that in the environmental laws, in the attempt, like in the criminal law, environmental law, Godavarman case, so many kind of the things are there. I'm sorry for the disturbance, and many kind of the things are there. So we could not able to say like that. Okay, fine. Then there are various rules and the laws. For example, then comes this one. That this one golden rule. What is meant by golden rule? We need to understand if the law is made, we need to understand the intention and the purpose of legislature. For example, if the lawmaker make a one law that the contract, we must give the contract to some individual or some company, only he defines only 4 5 construction companies for a road. Is it within the comes under the rule of law? Like the lawmaker have the intention to give some kind of the contract only to some kind of the 3 4 companies so that he get the political fundings. So is it right or wrong? Obviously that is wrong. That is what golden rule. Golden rule matlab purpose, context and intention of the legislature must be fine. If the law is made, we need to look at how we need to interpret. We need to look at the intention of the law. I will give one more cases also in the next rule. Okay, fine. When there is a mischief is there, mischief mischief rule. Mischief rule means when we could not able to decipher the intention of the legislature or a lawmaker, we could not able to rightly define the intention. What is its intention? For example, one of the cases there, electoral bond case. This is a very famous case. Like in 2024, Chandrachud gave the very good judgment about that. I will tell the facts of the cases. Okay, fine. Throughout the from the independence to the present time, like 2019, there was no mechanism for political funding. It comes under the Representation of People Act 1951, and there is no mechanism or there is no absolute tool to make a transparent or accountability for the institution. So there are various haphazard in the political funding. Everything is funded directly. Okay, everything is funded through the money. There is no. It is not transacted in the bank accounts. So what government did? Government amended the Representation of People Act 1951, and it included the one clause that every transaction for the political parties must be goes through the banking account, through the bonds. Okay, the companies need to buy the bond and they can donate to any political party, and it would be anonymous. Like no one can. It would be secret, and no one going to tell that what it is. So in the 2019 Supreme Court tell that it is very much fine, because in the previous laws there is no any kind of mechanism is not there. It is something is better than the previous laws. So it is benefiting. How it is benefiting? Everything transacted through the banking. So there is no this one tax avoidance. We can like not tax avoidance, tax evasion can be prevented, or a money laundering can be prevented. So a lot of black money, hawala funding, this and all kind of the things we can prevent that. So this kind of the decision Supreme Court told that in 2014 judicial review has been put, and the Supreme Court told that no, electoral bond, even though it is transparent, it is under the financial this one secretary of the SBI can able to look over that. Any one person, they have the access. Now, for example, finance minister, if she asks, give the names who have funded the political party, obviously the one in the power will going to get to know all the funding, how it is being taken. So what it did, it is a violation of Right to Information Act. A lot of it is violating the fundamental right of the citizens. So they have, when we are going to vote some kind of the political party, we should have the complete information about the political party or a person. So it negated such kind of the rule. So what is that? What that is the mischief rule. In the one of the famous case in the England, that case is called as hidden case. In the hidden case, there are four rules are recommended under the mischief rule. So if we could not able to find the intention or a purpose of this one uh, legislature, we need to look at the historical background. Is it better than the previous laws? Is there any defect kind of the thing? Is it going to benefit the society as in the large scale or not? So these kind of the dimension we need to think. In the Haydon case it is the court have given the judgment. In the England court have judgment. Even today, the Supreme Court, the rules of interpretation in the mischief rules hidden case being used. For example, in the electoral funding, is it going to benefit the society? No, definitely not. There is no democracy is means what? It is by the people, for the people, of the people. The people should get to know all kind of the mechanisms, like the how the funding is taking place. There must be a transparency. If there is no transparency, this is the violation of the fundamental right. This is how interpreted about the mischief rule. Okay, fine. Then go to the adjustem generis. What is that? What is that adjustem generis talks about? It talks about that when the in the law, when the specific word is followed by general word. For example, when we look at the Article 12 of the Constitution, state means what? State, it tells about the central legislature, state legislature, local bodies, and others. Others means what? It is a this central legislature, state legislature, okay, parliament, state legislature. These are the specific word, and others. Others means it is a general word. The specific word followed by general word. Okay, general word follows that. So general word, how we need to interpret? We need to interpret based on the context. In that, one of the cases that Modi Distillery versus the US one company is that the case went like that. In that, facts of the case is that in the Environmental Protection Act, sewage water or industrial waste should not this one directly you cannot this one give to the this one uh, the flowing water. Okay, clean water you should not because environmental pollution takes place. So at that time, what court interpreted that it followed that adjustem generis principle. So it told that is a distillery. Distillery water is some kind of the polluted water. Is it polluted water? If the tannery, if it is comes from the tannery, is it polluted? Is it harmful? We need to look at the context. What is polluted water? What is not polluted water? Distillery water is so much polluted. No, definitely not. But tannery, the water coming from the tannery, it is going to be polluted. So what it did, it literally this one this one it give the judgment in terms of this one Modi distilleries. Okay, then strict and equitable. That is what adjustem generis talks about. Adjustem generis means when the general when the specific laws followed by the general the words, we need to find that in the Article 12 also. Others is that in Rajasthan Electricity Board case, if you see that it said that electricity board also comes under the Article 12 of the Constitution. If any institution comes under the Article 12, what is the benefit for citizens? They can directly approach the Supreme Court, High Court under the Article 32 or Article 226 of the Indian Constitution. So it extended the scope of the rights, citizen rights. If it tells that electricity board does not come under the Article 12, means if electricity board do any kind of discrimination or if do any violate the rights of the citizen, you have to go to the district court, not the high court. So this is how the rights and the scope of rights being extended through the using the legal jurisprudence. Okay, fine. Then the next case is strict and equitable. What is meant by strict? Strict, this is mainly used, strict jurisprudence, this is used mainly in the tax laws. Some kind of the ambiguity is there. Strict jurisprudence is mainly used in liability cases. For example, I will give one case, that is that Vodafone case. It's one of the famous case. In the 2009, what happened is that Vodafone acquired the Cayman Island company's shareholding. It is outside the India. It acquired the share and Cayman Island held one company, East Air India, some other ex companies there. It held some kind of the company in India, and more than lakhs of crore being transferred, but it is not within India. What is the profit it is getting? It is transferred over there. It is an indirect transfer. And what Indian tax authorities claimed, they claimed 11,000 crore in 2010. It is approximately $2 billion, $1.8 billion they claimed from as a tax, as a capital gain tax from the profit of the taxation. At that time, it used the strict jurisprudence. In the Income Tax Act of 1961, is there any clause of this one? Indirect transfer, is there any mechanism? Or offshore taxation has been done, means outside India, can Indian authorities can put the tax upon them? So there is no other provisions for that. So what they did, Supreme Court argued this one, give opinion for Vodafone, and rejected this one filed by the Indian tax authorities. So what Parliament did? Parliament amended the Income Tax Act of 1961 retrospectively. It also comes that indirect transfer of the shares also comes within the capital gain tax. So they went to the ICJ, International Court of Justice in the Hague, I think so. So there also Indian tax authorities lost. So 11,000 crore never came to India, I can say so probably. Okay, fine. That is what strict jurisprudence, strict rules in the interpretation. In the strict interpretation, we only mainly used it in the tax laws, or where there is a liability matters. Okay, fine. Then equitable loss. What is in that? This one. Equitable loss mainly used for social welfare, labor dispute, industrial dispute. In that, one famous case is that is the Babita Punya case. In that Babita, I will tell the facts of the case. In that case, what happened is that in India there is no permanent commission for a woman. There is no permanent commission for a woman. And what happened is that Babita Punya went to the Supreme Court by telling that we don't have permanent commission, means we don't get the pension, we cannot promote to the higher ranks in the army or any armed forces. What Supreme Court told that women empowerment must be there. There must be a equality. Article 14 and 15 will be violated if you cannot able to give permanent commission based on the criteria. Like you set define kind of the criteria for male and the female. If female could able to cross that limit, you should have to allot them in the permanent commission. So it is one of the historical case where women were allowed to enter into the armed forces. So that is the one of the commendable cases where equitable this one interpretation means used. Equitable means not absolute equality, equity between the gender, equity between the caste, community, or equitable distribution of some kind of the thing, social benefits. It is many cases of that in industrial dispute, labor laws. If you look at that, many equitable this one interpretation has been used. Okay, fine. Let us go to the next. Next is that restrictive and extensive interpretation. What is that restrictive interpretation? Restrictive interpretation, I will give you one kind of the case. That is in 1954, Champakam Dorai Rajan versus State of Tamil Nadu. This is one of the wonderful case. I will tell the facts of the case that in the Champakam Dorai Rajan case, what Champakam is a woman, and there were only 4 medical seats at that time, and she cracked the exam. She got a 4th rank in this one Tamil Nadu medical entrance exam, and she got the seat. But at that time, Tamil Nadu government came up with the reservation for policy. In that, it told that the one seat must be reserved for SC/ST or backward classes. So what Champakam did, Champakam was this one Jamindar daughter. She directly went to the Supreme Court under Article 32, and she proclaimed that my Article 14 and 15 being violated, and Article 29 is also being violated under the provision of the Tamil Nadu government. At that time, what Supreme Court read that it take the absolute, what is given in Article 14 and Article 15, it take in very absolute manner that no, it is antithetical to the right to equality. You should not do any such kind of things under the laws. So it interpreted it in a very restrictive manner. So what is meant by extensive this one? Interpretation. Extensive jurisprudence means there are a lot of cases are there, like basic structure doctrine, Keshwananda Bharati case. In that Keshwananda Bharati case, what happened before that also? What was happening? There is a tussle between the judiciary as well as this one, executive and the legislature. What happened is that there were many laws being made which curtail the independence of judiciary. For example, 42nd Constitutional Amendment Act. It provided that there are some directive principle of state policy. If it takes any kind of the social welfare measures or socialist schemes under the laws, it is outside the ambit of the judicial review of the Supreme Court. What Supreme Court did, it curtailed the independence of judiciary or a basic structure of the constitution. So it negated many kind of the provisions within the 42nd Constitutional Amendment Act as well as 24th and 25th Constitutional Amendment Act. And I am not going to completely delve into these kind of the things. Just go through that. Okay, then Keshwananda Bharti case. What happened? His land been acquired by the Kerala, this one board. It is a temple land, more than 100 acres are there. It has been acquired. And what Keshwananda Bharti did, he directly went to approach the Supreme Court. And his this one, before that, Article 31 was considered as fundamental right, and later it is been transferred to Article 300A. So what Supreme Court tell that? Supreme Court given judgment for Keshwananda Bharati by saying that there are the fundamental rules and the laws. You can do anything and everything, like you can make any laws, but basic structure of the constitution must not be deprived, or basic structure must not be deprived. It was one of the famous case, and there were many cases are there, like NJAC, National Judicial Appointment Commission. It negated that. There are collegium system. What is collegium system? It comes through the extensive interpretation. It is not nowhere written in the constitution. It is comes through that extensive interpretation of the laws. Then this one, restrictive and then extensive, is been covered. Then rule of casus omissions. So what is not written in the laws? So you should not add anything and everything. It is just like interpretation must be interpretation. It should not turn into interpolation. For example, recently, okay, this one, when we look at the Tamil Nadu, this one I have a little bit of a critics about the court. I will give it to you. Okay, in the Tamil Nadu governor R.N. Ravi versus Tamil Nadu governor versus Tamil Nadu government case, in that case, what governor did was that he was withholding the bill. He had all kind of the power. Constitution did not define within this time limit you have to put the sign or you need to transfer to the president for signature. Until the president sign over that, it should not call as an act. It is called as a bill. So if it is a bill, it does not have any kind of the applications in the political domain. You cannot implement any kind of the laws. There were many bills he was objecting and he withholding the bill. At that time, Supreme Court told that you, within a certain definite time, you need to give sign to the bill, since this one under Article 200A it comes, and governor is a constitutional post, and in the constitution, in the name of governor is that, but it is all done to the elected authorities. How it interpreted means the post of the chief minister is elected by the people, and what governor have to do? Governor have to do anything and everything done by the chief minister elected by the council of ministers, and whatever they take the decision, governor have to give the approve for that. He could not able to reject that. He can reject that at a last resort, but he cannot withhold in a very unlimited, like he was withholding for more than 2 years. He can't do like that. So Supreme Court told like that. Then this one central government asked, you are like out of the ambit of your jurisdiction, like such kind of the things are going on. And this one, what is not there in the law, like as I first I told that what is not there in the law, you should not interpret. That should not, interpretation must not descend into an interpolation. What is there in the law, you can do that. What is not there, you cannot add anything, you cannot substitute, you cannot replace anything. I hope you got the point of rules of interpretation. There might be some rules, like various books write in a various ways. I have referred the two books. First one is V.D. Mahajan's book. It's going to be a good, extensive. And one more, I have a hobby of collection of the book. This book is written by M.J. Setna. So this is a wonderful book. This book is given in 1954 to my grandfather. So this book is going to be amazing. I have some kind of the hobby of collection of the books. So this is the class, and that we have seen the rules in the legal jurisprudence. The first rule is that Salmon gives grammatical and logical interpretation, and the second one is golden rule of interpretation. Third one is mischief rules of interpretation, and adjustum generis is, as I already explained, strict and equitable interpretation, restrictive and extensive interpretation, and rule of casus omissions. So these kind of the interpretation is there. And if you want mischief rules also, there are many cases. If you look at MC Mehta case, in that also it interpreted. For example, in Indian laws, there is a strict liability principle. The court come up with the absolute liability principle. What happened was that in the Bhopal gas tragedy, whatever the who will going to give the compensate for the victims. So what in the government, when we make the liability principle, as I already told, in the equitable principle, there must be a like equitable principle. It mainly applies during the case of liability. Who are liable for such kind of the extensive damage caused by this one oleum gas leakage case, Bhopal tragedy, we can call it as. MC Mehta directly go to the approach the Supreme Court. Supreme Court come up with the principle that is an absolute liability because they are the big pockets. They have to compensate all kind of the victims, even though it is caused by the this one act of God, disaster, damage, whatever it may be. You cannot do like that. So there are a lot of environmental laws. If you look at it, there are a lot of cases. Is that if you wish to understand that, understand it to how the judiciary thinks, how the lawmakers thinks. If you could able to understand it in a very extensive way, it will going to beneficial for you. And legal jurisprudence is such a subject. It is one of the subject in which you can think out of the box. That's why I like it. I hope you enjoy the class, and I hope you, if you enjoy the class, I'm not forcing you. If you feel so, you can share it with your friends or anyone who is doing the law or who is interested in law or whatever. It is your discretion of conscience. Thank you very much.